Hi guys, this is Lokesh with you and welcome to the 7th lecture of Jurisprudence class. As committed, today we'll discuss about the American modern realism and the realist theory of law. This school is a bit different because here the weightage is given again to the practical proceedings of court of law and not the statute. So hence this school is said to be a combination of two of previous schools, which is sociological and analytical. It is said that the realist theory of law or the American modern realism, both are same. It is a mix of sociological ideologies and analytical positivism. So it is said that when the sociological ideologies are given a proper weightage and incorporated in an analytical positive format, the realistic or modern approach of law comes into picture. So it is basically a functional and realistic study and not as contained in statute but as interpreted and laid down in the courts of law and the proceedings. So all the modern realists, they term realism as the left wing of the sociological jurisprudence, because if you see, it takes the sociological concepts which is resembling to the sociological school of jurisprudence, as it says law what is being practiced and not what is mentioned in the books or statutes. So this factor is common, and that is why some modern realists, they just believe that it is nothing different, but it's a left wing of sociological jurisprudence, while some of them say that it's not a separate school at all, it's just a branch of sociological jurisprudence. So this elaborates the resemblance of this school with the sociological school of law. Although in realism, the what is a key factor which plays in realism theory or realist theory of law or realism, the court decides a case based on the motive rather than the logical grounds. So that is important, because analytical approach talks about the logic and the analytism, while here it talk about the emotive or the psychological approach. There is a much greater stress on this. So there are three famous exponents which are related to them. One is Jerome and Frank. His period is 1889 to 1957. Another is John Chipman Gray. His period is 1839 to 1915. And this is the same gentleman, Mr. Gray, who gave us a definition of jurisprudence as a science of law, which we discussed in our first chapter. And the third important exponent is Oliver Wendell Holmes. His period is 1841 to 1934, and he is the one who determined or seen the concept of jurisprudence from the view of a bad man, which is the offender. So we'll see all these three jurists now, and we'll determine what are the drawbacks of this theory and what were the positive things of this school of law. So the first one is Jerome and Frank. He gave a beautiful work of him which is called Law and the Modern Mind, because he concentrated much on the revolutionary aspects of the law, because he tried to emphasize the powers of judge instead of whatever is written in the statutes. He said that judges do not make law, instead they discover it. Also, he said and emphasized on the temperament of a judge in the mechanism of law. He said that temperament of judge has an important bearing on the mechanism of law. He also guided the judges where the laws are not clear. He said that where the laws are frustrating, silly, vicious, or idiosyncratic, judges should resort to objective fact-finding process to reach the decision. So here it's clear to see that Jerome Frank, he emphasized on the powers of judge, and he emphasized law from the perspective of judges, and he said that whatever judges do, it's law. But also he said that judges do not make the law, instead they discover it. And this idea was to some extent was challenged by John Chipman Gray, who worked from the period of 1839 to 1915. Chipman Gray, he said that judges play a crucial role in making law in a given social system. And he just derived law with a two component. That what is law? Law is that. So the two parts given by Chipman Gray for the law is what judges declare during their proceedings and what rules they laid down in the determination of legal rights and duties of man. So what judges decide and what rules they follow, this only is the law as per John Chipman Gray, which was challenged to some extent later. Now the third exponent is Oliver Wendell Holmes. Now Oliver Holmes, he discussed law from the view of the bad man or the accused or the offender or the wrongdoer. And he also told that where there is a gap in law, judges should consider the precedent, whatever has been decided before. And where the law is unclear, judges can decide innovatively but not beyond the fundamental principles of law. So they should stick to the or adhere to the principles of law, and then they should decide the things innovatively. And Mr. Holmes also said that judges and lawyers, they are required to interpret law as it is without considering what it ought to be. So here he goes to the principle of analytical positivism. So that is the resemblance with the analytical school of law. Now for the three exponents, what is the similarity you have seen? The similarity is they just overpowered the judge. That judge is everything. Even Mr. Gray, he told that law is nothing but what judge decides and what rules he follow. So don't you think that they overemphasized the power of judges, and at the same time they minimize the relevance of books and statutes? So that is a common disadvantage of all the three exponents and the realist theory of law. So with this, I would like to wind up this American modern realism. And here, as a small topic, we can add or discuss about the economic approach of law also, what Marxist theory is and how it's related to the law. But because that topic is very small as per the syllabus of like first year law students, so I will just cover that very fast in a very quick manner, because it never comes in a big marks in the exams, and it is coming for a like a medium size question or a short type answer question. So what is economic approach of law? We should keep in mind only two important points, and there are certain assumptions. The economic approach of law says that economics is dominant in lawmaking. So here, for making of the law, the key factor is economics, and it dominates all other factors in making the law. Here it's worth to mention what Marxist economic approach of law is, which is a very important point. As per Marxist economic approach of law, law based on the will of the masses will create a society that is less unequal than what is based on the capitalist bourgeois law. So Marx said that the law which is based on the will of the masses, like interests of the people, and they say if that is the basis of the law, then the society which will form, it will be less unequal or it will be more equal than a society which is based on a capitalist structure. Now here, for the will of the masses, he elaborated that will of the masses, will of the common people, it should be the basis for all the rights, laws and judgments. And here, by this theory, he negates the importance of natural law, God, or even any absolute moral code, or even the power of statute. So this approach had quite like unrelatable assumptions also, which cannot be related with the present form of society. So if we see what assumption Marx made while determining the theory of the law or economic theory of law, he said that law is the product of economic forces, which is quite acceptable, because sometimes in the uneven or unbalanced sort of society, the economic forces, they determine the law. And also he told that law has to be is also considered as a tool of ruling class to maintain its power over the working class. The another assumption which is debatable, and a couple of people have commented and criticized that, is that there will be nothing called law in the future communist society. The assumption is that law will wither away in future communist society. So based on these assumptions, he gave his theory of economic approach of law, or basically economic theory of law, where he told that economics is dominant in lawmaking, and he emphasized the will of the masses, and he governed that all the rights, laws and judgments, they will be the consequences of the will of the masses. That is the Marxist approach of law. So that is a small topic. We just covered it alongside American modern theory. Hope you might have taken the benefits from this, and I will try to improvise the theories and my observations in the future discussions, and I will try to amend if anything new and fruitful is received by me. So till then, thanks for your time. Stay tuned and keep subscribing my channel. Thank you.